Dr. Agmare sir.
Yes, sir.
Good afternoon.
Good afternoon.
Sir, shall we start now?
Yes, please, sir.
Yes, thank you, sir. Ganesh, please proceed.
Am I audible, sir?
Yes, yes.
A very good afternoon, one and all present here. I, Ganesh Sikade, on behalf of Marathwada Legal and General Education Society's Manikchand Pahade Law College, Aurangabad, warmly welcome you all to this 1 week online lecture series on jurisprudence. This is the third series of 1 week online lecture series on jurisprudence. We feel honored to have with us Dr. Naresh Wagmare sir as a resource person for today's session, who will be enlightening us on the topic of sociological jurisprudence. I take an opportunity to introduce the resource person of today's session. Dr. Naresh Wagmare sir is a professor at Department of Law in Savitribai Phule University. Sir has completed BSL LLB from ILS Law College Pune and LLM from Department of Law Pune University. Sir is working as a coordinator at Human Rights Education SPPU Pune since 2018. Respected sir received Best Paper Award at National Seminar AKK New Law Academy in 2015 and International Conference TMV in 2017. Sir is having teaching experience of 70 years at postgraduate level in subjects like administrative law, criminal law, business law, and jurisprudence. Respected sir is also a research guide for LLM and PhD. Sir also participated as a resource person and presented papers in various seminars and workshops like Faculty Development Program, Workshop on Right to Information Act, Clinical Legal Education Workshop, Workshop on Book Publishing. Dr. Naresh Wagmare sir also has countless achievements to his name. Thank you so much, sir, for being with us as a resource person. Before moving ahead, I request all the attendees to kindly mute your audio and video. If you have any question regarding this topic during the session, put it in the chat box. Your questions will be answered by the resource person after this session. Now, may I request Dr. Naresh Wagmare sir to take over the chat. Over to you, sir.
Good afternoon, one and all. Am I audible?
Yes, sir.
So I would like to present my PPT, and the topic which is assigned to me is sociological jurisprudence. First of all, I must be thankful to the organizers, Principal Dr. C.M. Rao sir, who has taken this initiative to organize lecture series on jurisprudence. And you might have attended the previous, I think, 2 lectures on jurisprudence. And this is the third one, I think. And the topic which I suggested for my presentation, and which was, of course, here accepted by the organizers, that is the sociological jurisprudence. The sociological jurisprudence, the term itself is self-explanatory, self-evident, that it brings 2 branches of knowledge together. One is the sociology, that is the science of society, and another one is the jurisprudence, which is nothing but the science of law. So coming together 2 fields or the branches of knowledge, which makes here the sociological jurisprudence. And the Vice Principal, Dr. Sri Krishan More sir, also agreed on this topic for my presentation. And this sociological jurisprudence, of course, it is very much relevant and applicable to Indian society, Indian structure, or Indian legal system as such. And that's why I agreed to deliver on this topic. Here, we need to first focus on the emergence and development of this sociological jurisprudence. The first and foremost theory, which we all know, that is the natural law theory. And it is considered that the sociological jurisprudence is considered as the most significant development of the 20th century in the area of the jurisprudence. So this is the very significant development of the 20th century as far as jurisprudence is concerned. Then the first and foremost name which comes before all of us, who is none other than Professor Roscoe Pound, who led the development of this sociological school. The basic object of the sociological school we will see after some time. When I just mentioned about the natural law theory, the basic object of this natural law theory was the search for absolute justice. So when each theory has its own object to achieve, and this was the of natural law, then every natural law every natural lawyer who advocated natural rights as well, except Hobbes. And then we find the merger of two, the natural law theory and the natural rights together. Later on, as reaction to natural law, positivism emerged. And this positivism, wherein we find Professor Kelson, who has also talked about rights, but did not emphasize much on. Professor Hart, who has also referred to right. With this background, we see that the natural law theories and positivism, which were there, found inadequate to address the issues, or what we can say, the issues which emerge as to the advancement of science and technology and the changing nature of the state, laissez-faire to the welfare state, and we are still here discussing some background of sociological theory. The sociology term, or the branch, which was what we can say the promoted more by the August sociologist Auguste Comte. Here, law as an instrument of social control or social welfare, law as a device or instrument to create a society. This is what the main concern of sociological jurisprudence. The sociological jurisprudence here considers, or here what we can say the lawman as the social engineers. As we all know that the civil engineers who construct the buildings in the same way the lawyers, law persons the create or structure the society as they expect. Rule of law, when considering sociological jurisprudence, the sociological jurisprudence here that considers the function of the law as to is to here the construct the society or to organize here the human conduct in society. Professor Roscoe Pound's theory is popularly known as social engineering theory. As we know, that is this is the engineering or the construction of constructing the society as such. The facts which explained by Professor Pound as to the human nature, he found that, or he explained the facts of human nature, that human nature is acquisitive, competitive in nature. He wants more, ye dil mange more. So more and more are what we can say the greedy, the competitive. We always compare ourselves with the others. This is our human nature, he explained. And as we want more, our wants are more, our desires are more, and the resources are limited. So here the resources are limited, wants are unlimited. So they both have to be balanced. So how they can be balanced? This is to be done by law, which is an instrument of social control, as we have just discussed. So role of law as counselor or balancer. It has to balance our wants with here our resources. So resources, according to Professor Pound's theory of social engineering, resources shall be utilized with minimum or less friction. When we have to utilize natural resources or whatever the material resources, we must use this with minimum friction. There should not be, or there should be very less friction, conflict as such while utilizing these resources. The basic aim of sociological jurist is to social control, as we just discussed, and the law, which is an instrument of social control. And this theory is also called as theory of justice, as the balancing is done by the law, and the balancing of the things, or here we are going to discuss here the interests are nothing but here the desire is the justice, doing justice. So social engineering theory is also called as a theory of justice. Professor Pound has defined that the rights or the right is an interest, which is interest is nothing but our desire, our claim, our wish, which is recognized, protected, and enforced by law. So legal right, according to Professor Pound, is nothing but it is basically, essentially, an interest which has been here recognized by law as rights and protected and enforced by law. This is the right. So here the rights, legal rights and the interest, these two, what the keywords we find here in this definition. Professor Pound says that social life is disorder one. It is disorderly one, where law has to bring that social life into order. So basically here our social life is disordered one. It has no discipline, and this discipline is to be brought by using law. So the law has to bring social life into order. Here, as we discussed, that is the right is nothing but an interest. Interest is nothing but here the claims, de facto claims, or our plain wish, will, that we want something. Okay, it may be any things, material or non-material as such. So these de facto claims exist in every society, independently of the legal system. If you remove for the time being our legal system, our legal rights, then we find that every individual in our society wants something from others, from the state, from the governor or the rulers as such, from our neighbors, from friends, from relatives. So these de facto claims exist into every society independently of the legal system, or irrespective of legal system. We do find there are some de facto claims, or here the the wishes of the people. When do these claims turn to be right or become devices as such? So when these, our wish, suppose I want to have good occupation or employment, that is our desire. Now when that becomes the right, so our wish, when it converted into right, as right to employment, right to occupation as such. So he, Professor Pound, has suggested 4 stages how our de facto claims, desires, wish converted into our legal rights. So the interest or claims to legal rights, this is the journey. The first is ascertainment of those de facto claims in a given human society. What are the claims in our society? Okay, what are the desires of the people? That must be ascertained, that must be identified, or that must be first collected, or collection of the data, information about what people actually want. That is ascertainment, the first stage. The second, giving legal support to those claims which are determined or decided. So each and every claim cannot be, or it's not possible to identify as right or to recognize as right. So suppose, for example, LGBT community, they have they wish, they want some protection, some rights to be entitled on them from the state as such. So each and every right cannot be recognized as such. So these here the system, legal system must identify, determine that which can be protected by the law. Okay. Then laying down the limits within which those rights would be recognized. We know very well that each and every desire cannot be converted into right. Okay, there are certain limitations. So while recognizing the rights, we need to limit restrictions, because no right is absolute one. So there need to have some, in order to balance with the others' desires, we need to restrict these claims. So some limits to be put on these rights, and the enforcement about of these rights. So enforcement machinery is essential one. Otherwise, those rights have no meanings. So these are the 4 stages how the interests are converted into the legal rights as such. So ascertainment of claims, giving legal support, recognizing these claims as rights, putting here the limits on these claims, and the enforcement agency of these rights. Then de facto claims are independent, as we have just discussed. These are independent, irrespective of legal system, and not the creation of law. De facto claims de jure rights, that is the creation of law. De facto claims are not the creation of law or of a legal system. It does not mean that they are invaluable. So it is not that every right is valuable and de facto claims are not valuable as such. De facto claims as well valuable one. Scheme of interest. Here Professor Harold Lasky in his book Grammar of Politics, he talked about the existence of the de facto claims in the legal system. Then it is not because legal system recognized them and they became important, but they are factually important one, according to Harold Lasky. According to Professor Pound, that is the social engineering theory or the sociological jurisprudence from the Professor Pound's point of view is to see the effect of interest, de facto claims on here the law, which has recognized these de facto claims as the rights as such. So the effect of rights on here the law, or here the effect of interest on the law is basically the primary concern of Professor Pound. And we know that is our desires, wants, they change from time to time, place to place, society to society. So that must be also taken into consideration. Professor Pound has evolved or advanced a scheme of interest, de facto claims as such, or interest, desires, scheme of interest. And according to him, that it is nothing but scheme of justice. This scheme of interest, which we are going to see, is nothing but the scheme of justice, which is ultimately to deliver here the justice. So it is branded as, this is considered as the scheme of the justice. This theory is branded as the theory of justice, and he has classified the all interest into three categories, and that is Professor Pound, and his scheme of interest is the scheme of justice. Before going to discuss the categorization or classification of interest, we need to understand that whatever he has talked, as he was from here the USA, so he developed his theory with reference to in context of here the American society. So he, while propounding his theory, that means the theory is applicable only to a society which is democratic one, civilized one, and matured at cultural level. So as to the applicability of sociological jurisprudence or social engineering by Professor Pound, this theory is only applicable to a society which is democratic, which is civilized, and matured at cultural level. You know, the culture of the society, as we know, that each and every society has its culture, and the culture, it also changes from time. Today's culture of Indian society may not be the tomorrow's culture, so it changes from place to place as well, time to time. So the applicability of the theory is concerned, it is applicable to only democratic, civilized, and matured society at cultural level. Then this cannot be applied to a dictatorial regime. The theory cannot be applied in a disturbed or destroyed society. Okay, so that is, in other words, the corollary of the first one. The society shall have homogeneity. Now the homogeneity doesn't mean one religion, one language. Okay, so irrespective of different languages, different religion or the culture, there must be the feeling of common brotherhood, or here the unity in the diversity. So a society which is united of the different opinions, or here what the languages and the regions and whatnot. So that is a homogeneous society according to Professor Pound. And to that society, the theory may be applied and not to otherwise. Now, as these interests classified into three, before going to see here the three classes of interest, it is an essential to see what is the nature of three classes of interest. See, three classes of interest, these are not opposite to each other. Means the individual interest is not against the state interest or social interest as such. So these are, we need to understand, though there are the classifications of interest, these the classes are not opposite to each other. Then these interests of one particular class, these are just the point of view. Okay, the individual interest, it is individual interest, the class is nothing but the point of view from an individual. Okay, an individual's point of view. It is the individual interest. State's point of view, state interest. Social interest, social point of view. Okay, so these interests we cannot keep as in watertight compartments or the separate as such. These are overlapping or interchangeable as well. The interest as such, so there are the various interests in a given society, and if we, as the scheme of interest classified these interests into three, individual interest, social, and the state interest as such. Here, the function of the law is to balance, okay, in case of conflict, okay, these balancing of the competing and conflicting interest. How these are to be balanced? So these interests conflict at some point of time or compete with each other. At that point, these are to be balanced with the help of an instrument of law. So here, this social engineering theory considers law as an instrument to balance the competing and conflicting interests, according to Professor Pound. Professor Edwin Patterson, who was the student of Professor Pound, he has mentioned a very important point, that is here social interest, which is one class of interest, is the major device of balancing competing and conflicting interest. So in case of conflict between individual interest and social interest must be given priority. Okay, the social interest is a device of balancing competing and conflicting interests. This is how the priority, one must give here the priority, and Professor Edwin Patterson gives here the priority to social interest in balancing these competing interests. The human society at cultural level, that as we know, the democratic, civilized, matured at cultural level. So the culture it differs from society to society. It has some values, ethics, and morality. The culture of a particular society may not be the same, as after decades it changes from time to time. So here, and in this, what the changes we do find, the development of the new interest and the conflicts and the competitiveness and the balancing to be done by the law. So when there is conflict between interests, then law solves conflict with the help of two solutions, the legislative and the judicial. Legislative, that is the lawmaking, and the judicial, that is through the interpretation of law by the independent judiciary. So the two solutions in conflict of the interest. The social interest is not interest of society only, but also of individual and state. So here, be it an individual interest or state interest or social interest, in all these interests, we do find the existence of individual interest. So all these are basically interest of individuals only. The society, which is composed of individual, is of individuals. The state, it is in existence. It is for the individual. So here, be it here the social or the state interest, all these are basically here the individual interest. Professor Pound also mentioned about the recognition of the minority rights or the minority claims in human society. So minorities, of course, in democracy, we find, as he mentioned, this applicability of the theory in democracy, especially in representative democracy, we do find the democracy is nothing but the rule of majority. And what about the minority representation or their claims? These must be recognized by the law. And in constitutional democracy, these are already in existence or recognized, as we find Article 29 and Article 30 in our Indian Constitution. So recognition of the minority rights in human society. When Justice T.N. Scallon, he observed that he taken freedom of speech and expression as an interest, as an example, and he analyzed that right to freedom of speech and expression, that this one particular right involves interest of all three: interest of an individual, interest of the state, interest of the society. So here, the first, it is the interest of the speaker. Second, it is the interest of society that helps. And the third is the interest of the state, which is the national integrity and all other things. So when one person exercises right to freedom of speech and exercise, that fulfills the interest of society as well, because the audience also receives some knowledge. The state which involves the participation, and this participation through the exchange of ideas and the knowledge and etc. So that helps also the state. And these interests are with reference to these three, all these three are interrelated. One interest at one time maybe in the individual interest, in another time maybe in the state interest as such. So the interchangeable, these interests are interchangeable as well. Now, particularly the scheme of interest, we see that the three classes of interest, and one is the individual interest. Now, individual interest is involved of three types, or the subclasses. One is interest of personality. Every individual has rights which are attached to his personality, character, or individuality. For example, right to life, which is attached to his personality, liberty, freedom from torture. So all these are nothing but here the rights, okay, the claims which are attached to an individual's personality. Then the second, under the heading of individual interest, we find the interest in domestic relations. Every individual human being has freedom of choice to enter into wedlock or the freedom of marriage as such, to have a spouse, to have a kid or children. Relations, so in this domestic relations, these are basically governed by law. And these domestic relations would be in the nature of a living relationship or maintenance to wife or to old age parents, etc. So here this individual interest in domestic relations need to be recognized by law as well as protected. Then the interest of substance. Okay, this is the subclass of here the individual interest. Interest of substance involves or includes pecuniary, monetary, or financial interest of an individual. Okay, here as this is related to substance. So here the freedom of employment, right to work, continuity in employment, right to property, right to contract, right to carry on business, freedom of occupation, and so on. All these come under the subheading of the interest of substance. So in the scheme of interest, the first interest is of an individual interest, and herein the interest of personality, domestic relations, interest of substance. The second is the state interest. So here the state juristic person, as we know that in jurisprudence, personality, concept of person is there, and the state is recognized as person. So state as juristic person, state which is nothing but an institution has its own personality, or here the legal personality, it has its own interest, and those are to be recognized, protected, and enforced by law. Then the state as guardian, it is based upon the principle of parent patria. Nobody is guardian, but it is the state only who becomes guardian of all. For example, that is in Bhopal gas case, the institution of state played a vital role as guardian. So what we can say that jiska koi nahi uska sarkar hai, or the law as such. Then the social interest, the third category, wherein we see that is the interest of general social security. So in a society, there has to be an order, peace, and tranquility, and need of the criminal law of torts to maintain peace and order in the society. Because here the society cannot progress without the peace within the society. So the peace is the first and foremost an essential element for progress and development. So the social interest in social security. Then the interest of social institutions, political institutions, political interest, okay, the religious institutions, family institutions, even economic institutions, and so on are nothing but social interest. So the social interest related to these all here the institutions. Then the interest of general morals. Every society has its own moral standard. Okay, for example, the corruption is considered as immoral. Okay, so here the corruption-free society. So that is the social interest. The corruption-free society wherein the social interest is involved. Interest of social resources. All sources, all resources are important, be it here the natural and what we can say the material one. All resources shall be conserved for future social life. And here the emergence of the sustainable development. So whatever the resources we must utilize for ourselves as well for the future generation. We should not be so the greedy to think only of us. Then the interest in general progress. So political, what we can say as we say the political democracy or the political justice as such. So the political developments in a better way, in the right direction is always required. So the progress, political progress, economic progress, cultural progress. So herein also the social interest is involved. Then the interest in individual life, the social interest. See, we think that is I am an individual. So I need not to think of others, but others also think about you. Okay, so others, we are dependent on others as well. So our family also or our society takes also interest in you. So here the social interest is also involved in an individual's life. So here the political life of an individual's physical, cultural, and social and economic life of an individual is here considered in this subcategory of social interest. See, whatever the schemes of interest, that is an individual interest, social, and here the state interest and social interest, all these interests, or particularly here this scheme, this was re-evaluated and reassessed by Professor Selznick. And we find that this sociological jurisprudence, this has been developed into 3 stages. One is in 1962, that is when the Professor Pound's theory developed this. Okay, and this is the first stage wherein the Professor Pound himself and his followers come in the first stage. The second stage, wherein the lawyers, okay, who are nothing but here the social engineers, with the advancement of here the technology and the research methodology, here enacted the laws in a better way or promoted the legal system, the second stage. The third stage, according to Professor Selznick, he said that the third stage of the development of sociological jurisprudence is yet to come. That he mentioned all these 3 stages. That the first is of here the Professor Pound and his followers. The second is of here the lawyers, and the third is yet to come. However, we do find the Professor Finney's natural law theory, which we can consider as the third stage of the development of sociological jurisprudence, which is nothing but here the coming together of natural law theory and social engineering theory together, which he developed in the area of in the year of 1980, and he developed the notion of justice through his theory as well. And what Professor Phineas, he talked about 7 basic common goods and 3 methodological requirements which leads to the achievement of the justice. So the third stage of sociological jurisprudence by here the Professor John Finis. Now, we may conclude that we mainly discussed Professor Pound and his social engineering theory, that in a society, okay, we may conclude that the sociological jurisprudence is much more related to law and sociology. Law cannot be studied, or it does not work in isolation. It works in society. Sociology studies here the society. So there is the relationship between law and sociology, and the jurists or the sociologists who have studied the sociological jurisprudence or who led this school. So the sociological school, see, the school means here what we can say the thoughts. See the thoughts of Duguid, Ehrlich, Eyring, Pond, Combe, all, if you consider there are some similarities, or all these thoughts of these sociologists and jurists are based on one common premise or the principle, that here we do find here the law is an instrument of social control or social welfare. Okay, what the law it does. Okay, here we will see what the Ehrlich he talked. He considered that is the main source of law is the society. Okay, after all, the law has to work into society. So what the society or what the individuals in the society want for them, for that purpose, the law is existence. And he developed the term, the living law, that relationship amongst the individuals are governed by the law, especially. Then the Pound, as we discussed, that is he developed his social engineering theory, and he considered the law as an instrument to balance the conflict and competing interest in the society, and it has to bring maximum happiness with a minimum friction. He also talked about, Professor Pound, he also talked about jural postulates. Jural postulates that be it Western or Eastern or be any kind of society, we find there are the common interests which need to be protected and or promoted by the legal system. And he talked about jural postulates, and that the interests which need to be protected through here the criminal law, or the peace and order must exist in the society, and for that here the criminal law is needed. A law of patents, law of contracts, law of torts, strict liabilities. So all these are to be there in the legal system of any society. Combe, who is considered as the founder of sociology, and he developed the organic theory, that is, if the society is organized one, then it can do progress, or otherwise not. So there is a theory. The Duguid, who talked about social solidarity, is known for social solidarity, or what we can say the fraternity, or here the common brotherhood as such. We as one, united one, and we all need to perform our duty to promote this social solidarity. So this is about here the Duguid. So we do find that there are many others who have contributed to the development of this sociological jurisprudence. Eyring, who talked about here the promotion of social interest in the scheme of here the interest. So I, with this brief, because I have to deal each and every aspect in a given time, so I covered in a hurried way that the presentation. So I would like to answer your questions. Before that, I must express my thanks to the principal, Dr. C.M. Rao sir, for organizing such a nice and important lecture series on jurisprudence. So I, to the best of my knowledge, this is the first one one activity which emphasized mainly on the jurisprudence. Jurisprudence is much more ignored or neglected area in the study of law. However, this is the fundamental subject which need to be studied by every student. So whatever I could deliver to you, it is only the blessings of my teacher, Professor Dr. Dilip Uke sir, who taught us here the jurisprudence subject. So here I express thanks to Dr. C.M. Rao sir, then Professor Sri Krishan More sir, Vice Principal, who here organized this the lecture series and invited me as a speaker, and Dr. Aparna Kotapale ma'am, IQSC coordinator, then Dr. Amol Chavan, Mr. Ganesh, who introduced me, and the students and the participants on this occasion of lecture. Thank you, one and all.
Thank you so much, sir, for delivering fruitful and meaningful lecture. Sir, with your kind permission, shall I read the questions?
Yes, please.
There is a question, sir. Can we say that law is an instrument of social change? If yes, then how?
When we consider this sociological jurisprudence, of course, law is an instrument of social change. Okay, laws are made, these have been made to bring social change. Of course, that is the object of law, to bring social change, social transformation. However, here the participation of the people is very important. The laws are made, laws are in text, but not in action. Then what is the use of this? So basically, this sociological jurisprudence emphasis more on the impact of law on here the society as well. So my point is that law brings social change. However, here it must involve the people to bring here the social change, the participation of the people, or the participation of each and every individual. So here the mindset of the people is an essential. Yes.
Now there is one more question, sir. Sociological school, is it modern approach to law?
Yes, we can say so, because each theory, when emerged and developed, further this was also led by for example, in the Eyring is considered as the father of modern sociological jurisprudence. So we do find that each theory has its future as well. So this is also.
Sir, next question is that what is the impact of this theory on the society in percentage? If possible, give the example.
Yes. In Indian context, we can say Article 19, Clause 1 subclause A, which guaranteed a right, that is the right to freedom of speech and expression. And at the same time, so when, see, everyone has has wish to express, to speak. Okay. So this is the one, what we can say, the de facto claim or wish, desire as such. This is recognized by the law. Okay. Now, there are certain restrictions on our right to freedom of speech and expression, right? What we can say are our freedoms as considered, our whatever the freedoms are concerned. So there are certain restrictions, and these are put in the names of public morality, public order, okay, public health as such. So what the point is that public order, public health, public morality, order, health, like this, these are nothing but here the social interest is involved in this. Okay, so when I have a right to freedom of speech and expression, or for example here the right to freedom of religion, but this is subject to here public order, public health, public morality. So here that social interest, so in this conflict, what the social interest is prioritized. Okay, so my this right to freedom of religion is subordinate to public order, public health, and public morality. So this is what we can say. This is more applied and applied to our Indian legal system as well. Yes.
Thank you, sir. There is one more question also. If there is a conflict between state interest and social interest, then what is the position of law?
See, as we have just discussed our theory, taking into consideration the theory, here the social interest must prevail over here the state interest. It must prevail, social interest. After all, here the state is there for the society and the individuals. So social interest must prevail, but due to certain the social interest
Or queries?
Yes, pardon?
No, sir, continue.
So the social interest, yes, social interest must prevail over here the state interest.
Sir, Dr. Wagmare, sir.
Yes, sir.
May I request you to kindly explain why social interest should be prevail over the other interest? That will be better if you can focus that.
Right. See, theoretically speaking, here the society is composed of individuals. Okay, society is composed of the individuals. Society, the state, it emerged and developed for the society or for the individuals as such. So while making the laws, the state must take into consideration the social interest, and the social interest must prevail. For example, I must refer to the present situation. That is, we do find that laws are made by the Indian Parliament related to the farmers. Okay, so they are the representatives. Our MLAs and MPs, they are the representatives. They have made the laws for us. However, we do find that there are the opposition to the laws. So if the laws are made for the benefits of the society and the society do not see any benefit in the laws, then the state must consider this and protect the social interest. That is the thing, sir.
Thank you, sir.
Thank you.
Yes, Ganesh, proceed.
Thank you so much, sir, for solving our queries. It gives me an immense pleasure to express my vote of thanks on behalf of this esteemed institution. I take this golden opportunity to thank Dr. Naresh Wagmare, sir, who has spared his precious time for us. I express my sincere thanks to our respected principal, Dr. C.M. Rao, sir, who always provides direction and motivation to us to learn and try out new ways to do things better. I am also thankful to our respected Vice Principal, Sri Kishan Mori, sir, IQAC Coordinator, Dr. Aparna Kotapalle, ma'am, and Faculty in Charge, Dr. Amul Chavan, sir, for their valuable support. Last but not least, I sincerely thank all the teaching and non-teaching staff, technical member, and all dear attendees for making your valuable presence. Once again, I thank one and all. Before ending this session, I request all the attendees to remain present tomorrow at 4 p.m. for the next session. Dr. Tejaswini Malegaonkar, ma'am, Assistant Professor, ILS Law College, Pune, who will be dealing with on the topic of American legal realism. Thank you so much. Stay tuned for next session.
Thank you very much. We are going to end this meeting.